Good Friday afternoon. Today is March 24, 2023, and this is a video of today's class. In the event you want to go over the information that was provided today, if you want to check your understanding of the doctrine, if you want to check your understanding of how the exceptions work, etc., etc., here's the video. Ready? Let's go. We are continuing with owners and occupiers of land. And today, the two cases that we are going to review together and discuss together are cases where we have a landlord-tenant relationship, a landlord-tenant relationship. But before we get there, this PowerPoint was shared on Canvas prior to class, so you already have the PowerPoint. You already have the schedule update. I printed this for some students. It's really hard to see on the print, but I snapped it and so cut and pasted so that you can see. Now that I understand that my exam questions are due at the early part of April, I'm making changes to the syllabus, and I wanted to go through those together. Today is March 24. The two courses that we are going to review and discuss together today are the Borders v. Roseberry and the Newton v. McGill. The Borders v. Roseberry and the Newton v. McGill. All of those submissions should have been done online. I will get those graded over the weekend, those briefs graded over the weekend. And for Monday, the 27th, we have the Lundy and the Moody. That's Lundy v. Adamar of New Jersey and Moody v. Delta Western. Those are the cases we are going to review and discuss on Monday. I will open a link on Canvas so that you can submit those electronically. March 29th, we're going to go with the Henri case, Philadelphia versus Philadelphia Center. March 31st, we're going to do the James versus Laib case. On April 3rd, we're going to do the Greco v. United States case. On April 5th, we're going to review Borders, Newton, Lundy, Mooden, Henri, James, and Greco, because that's going to be the end of the special duty rules that we would have covered for the semester. April 7th, we will not meet. That's a Friday because that is your Easter break. April 10th, we will not meet because that is Monday during your Easter break. April 12th, April 14th is going to be a review, go over your briefs, make sure you have everything that you need. April 13th, if you would like to volunteer, there are volunteer opportunities to serve for the trial advocacy course that I teach. We're going to be having final trials, and we need jurors and witnesses and timekeepers. I will post a sign-up sheet on Canvas if you're interested. If you're going to participate, understand it's voluntary. There is no extra credit. The extra credit is the experience that you have. I will try to arrange for dinner, so I don't know if that's deemed an extra credit, but there will not be any extra credit points. However, it's going to be great experience. If you're going to participate, the trial will start at 4:15. I will need you probably by 4 in the moot courtroom. I will need you until it's over, which is at 7:15. Okay. If you have class on Thursday, April 13th, from 4:15 to 7:15, I do not expect to see your face. You will go to class. And if you don't go to class, it won't be because you're volunteering for my trial ad class. Two more opportunities for the volunteer. That's on April 14th. That's going to be noon to 3. And then April 14th as well from 4 to 7. So there's 2 additional Friday opportunities to volunteer. Again, if you're going to volunteer from noon to 3, I need you there for that entire time. If you're going to volunteer from 4 to 7, I'm going to need you there for that entire time. What are we going to do on April 17th, which is the next to the last day of class? We're going to review. What are we going to do on April 19th, which is the next to the last day of class? We're going to review. What is this slide? Never be confused. This is the tier 1, tier 2 of duty of care and how to test for duty of care. that we went over in the previous slide. So this is just an empty slide. The duty hypo, again, we talked about tier 1, which is the general reasonable person standard, and then tier 2, which are alternatives to the reasonable person standard, because sometimes the reasonable person standard is just insufficient or inappropriate or just doesn't do the thing that we needed to do. Customs and practices is a perfect example. Negligence per se shouldn't be right there. That is a typo, which I will fix and then repost. But customs and practices we've talked about in class. That was the Osborne v. Irwin Memorial Medical Center, the Russo v. Griffin, and the Carbone v. Tierney. So these are things that we've talked about. These are things that we are familiar with. These are things that we understand. And what I hope I'm doing is just placing them in a larger context so that you can see the big picture. Let's talk about class today. What did we discuss in class today? We talked about landlords and tenants. Specifically, we discussed the duty that a landlord has to either a tenant's social guest, right, or to a tenant themselves. So does a landlord have a duty to discover and to repair known dangers before a tenant takes occupancy? Does a landlord have the duty to discover and repair known dangers so that the social guest of the tenant isn't harmed? Old way of thinking was caveat emptor. Caveat, EMPTOR. Let the buyer beware. As is. Take it as you see it, right? Under caveat emptor, tenants had a right to be on the property, right? Because of the commercial agreement between the tenant and the landlord. That commercial agreement was for the benefit of both parties. And as such, that commercial agreement, that conveyance, right, that lease, right, served as a property instrument of conveyance, which allowed then the tenant to stand in the stead of the landlord. What does all of that mean? That means that the tenant, not the landlord, would be responsible for any negligence or for any harm because you take it as it is, right? That's the common law, older version. Had a student ask, why are we learning the old in order to learn the new? For caveat emptor, we're learning the old because the old is still good law, right? To this day, there is a caveat emptor. Now, what we're going to learn from Borders is that there's an exception. In fact, there's 6. And what we're going to learn from the second case is that there's an additional exception, which is a warranty of habitability. So don't think that just because it's old, it's been replaced. Caveat emptor has not been rescinded. It is still great law, right? But we start there so that you can see how and why social policy drove the creation and the acceptance of these exceptions, how social policy grew and created the understanding and the implication of a warrant of habitability, right? Nothing that you see is new under the sun. It might be new to you, but it happened to someone at some point in the existence of time. This is all rerun. And sometimes we need to understand what the predecessor was to what we currently have, because maybe we don't like what we currently have and we need to change it. Be that a law, be that a statute, be that a regulation. But what are we going to change it to? If we don't know the history, right, our future is doomed to repeat our mistakes. So everything that might be new and shiny ain't the way you need to go. You might need to go with ugly and steady, right? Caveat emptor has stood the test of time, with the exception of 6 exceptions and the warrant of habitability. So let's move on. Borders v. Roseberry case. What's the issue? Here's the simple down and dirty. What duty of care does the landlord own to the guest of a tenant? Boom. Can we do that as an under does when? Absolutely. If this were a final exam or a summative, I would expect a under does when or whether when. But just to get to the meat of this, what duty of care does a landlord own to the guest of a tenant? Generally, none. Okay, so what duty of care does the landlord own to a tenant? Let's go with the general rule, none. Okay, great. We know what the status of the law is as we start this case. Let's start this case. What are the facts? Defendant landowner owns property. Defendant landowner leased property to tenant. Defendant landowner remodels property just before the tenant moves in. The repairman that's working on behalf of the defendant landlord removed the front gutters and failed to install them. So, okay, so what? So what? Without the gutters, when it rained, the whole front north portion of the house drained onto the front porch. In winter, when you've got all of that water draining off onto the front porch, it freezes. What do you have? A slippy, a slippy, watery mess. Okay, that's what we got. The landlord knew that the repairman did not complete the repairs, meaning that he did not reinstall the rain gutters, meaning that there's going to be rain accumulation on the front of the house from the north side of the house, meaning there's going to be ice, meaning somebody's probably going to bust their butt, right? Somebody's going to get hurt. Yeah. If you don't add this fact to your key facts, you're probably going to get at least a 4, right? Because this next fact is a fact that actually turns this case. Not only did the landlord know that the gutters had been removed, that the gutters had not been reinstalled, that without the gutters, there's going to be rain accumulation. In the winter, that rain accumulation is going to turn into ice, and that's going to create a hazardous condition. But the tenant also knew. The tenant knew that there were no gutters. The tenant knew that without the gutters, that the rain on the north half of the house was going to accumulate. It was going to turn to ice, and it was going to be a mess, and somebody was going to get hurt. What did the tenant do? The tenant complained to the landlord, this needs to be fixed. What else did the tenant do? In spite of this clear, dangerous situation that the tenant knew about, the tenant invited over a social guest. The tenant invited over a licensee. Tenant cooked dinner, licensee came over, had a great night. Licensee, the social guest, the company left, walked over the ice, fell, didn't bust their ankle, that's the other case, but fell and injured themselves. The guest, not the tenant, the guest is the plaintiff. And mind you, the guest did not sue the tenant. The guest sued the defendant. The deep pockets, right? I put a little notation here, and we talked about this in class today. Why in so many leases where you're leasing tenancy today, you're required to get renter's insurance? The reason that so many landowners, landlords, lessors require So many of them require renters insurance from their tenants because what happens? I have a guest that comes over. The guest sues the owner. Guess what the owner now gets to do? Because one of the requirements was that the leasee have renters insurance. The owner now gets to seek indemnification. Right? All of this stuff is like, oh my God, is that why they make me do that? So yes. So yes. The guest slash plaintiff filed a suit of negligence based upon the grounds of a defective condition. There were no allegations that the guests were themselves negligent. If your mind is racing to contributory negligence and comparative negligence and assumption of the risk, kiss yourselves. Kiss yourselves, kiss yourselves, because you are brilliant mind genius. Kiss yourselves, kiss yourselves. That is exactly the way that your mind is supposed to work, but you must not act upon it. The call of the question, the issue is, what liability does the landlord own to the guest? We're not looking for potential defenses, assumption of the risk, failure to mitigate, contributory negligence, comparative negligence, right? But if your mind started to say, oh my goodness, this could lead me to one of these things, then you're spot on, you're absolutely right, and your mind is working brilliantly. But you got to stop, because that's going to have you responding to something other than the call of the question, which is, what is the duty does the landlord have to the guest? Okay. Procedural history, the guest files a lawsuit against the landlord. We've got some pre-trials. We've got a bench trial. What's a bench trial? That means that we don't have a jury. We've got a judge who's making the call. We've got a bench trial, and the judge ruled in favor of the defendant, landowner, landlord, lessor, because that was the general state of landlord immunity, right? The tenant stands instead for the owner. It's the tenant's responsibility to discover and make right anything that needs to be made right. That is the general caveat emptor rule, right? The guest says, I see what you're doing, judge, but I think you're wrong. And so I'm going to appeal. That's your procedural history. What's the rule? The rule now allows for 6 exceptions. So what am I saying to you? Caveat emptor is still good rule, but now we have 6 exceptions. So the rule that I'm looking for in your briefs is you make mention about the exception, right? If you put the 6 exceptions in the rule, and maybe you put the 6 exceptions in the reasoning, great. Put them in both places, because sometimes one fact, one element, one rule, one statement is multi-purpose, means it might need to be in multiple places. But of all things, make sure it's supposed to be where it's supposed to be, which is the rule. So what are the 6 exceptions? Here we go. Landlord's liability to a licensee, that is a social guest, that is a guest of the tenant, for a defective condition existing at the time of the lease, is still good law, meaning there's no liability, except for these 6 exceptions. Undisclosed dangerous conditions known to the landlord, landowner, lessor, but unknown to the lessee. Conditions dangerous to persons outside the premises. That's your pit bull run wild. Number 3, premises leased for admission of the public. Number 4, parts of the land is retained in the landowner's control, which the lessee/tenant is entitled to use. Exception number 5, where the lessor or the landlord contracts to repair. Ooh, 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 ooh. Exception number 6, negligence by the lessor or the landowner in making repairs. If you want to see what just a good analysis looks like, where you're taking kind of what we did on Wednesday, where you're taking the facts and the elements and you're testing that against the law, look at page 623 in the Borders case, where the court is executing their analysis. That is textbook perfect. They went through exception one. What are the facts? What are the facts? What are the facts? What are the facts? Nope, not exception one. They went to exception two. What are the facts? What are the facts? What are the facts? What are the facts? Nope, no facts. Went to exception three, right? So they tested each of the exceptions with the facts, right? I'm testing this rule. I got to have some facts in there to test it. And as a result, I'm going to get an answer. What's the answer? The court affirmed the lower court's ruling. What was the lower court's ruling? Let's go back. The lower court's ruling was in favor of the landowner defendant. What are you saying? Are you saying to me, Washington, that the general rule is landowners have immunity from liability, right? They don't have a duty of care. They don't have an obligation, right? Except for 6 exceptions. And then you take me around the world, right? Looks like feels like I'm wandering for 40 days and around the world through these 6 exceptions, only to tell me that neither of the 6 exceptions apply. It's exactly what I'm telling you. Why not? Why did the reviewing court affirm the judgment in favor of the landowner, which said that the landowner had no duty? I thought number 6 was really good. The exceptions come into play, number 6, only when the lessee, that's the tenant, lacks knowledge. This is one of those situations really more closely to exception number 1, where the lessor knows about a dangerous condition and the lessee doesn't, right? But we use number 6 because there was actually repairs that were taking upon themselves. Even though the landlord hired somebody to take on the repairs, and even though the repairs were either negligently done, or in this case, not done at all because the repairman didn't reinstall, he just didn't finish, the landlord escapes liability when at the time of the delivery of the conveyance of property, if at the time we've executed the lease, I've given you the keys, you now, tenant, stand in my stead. If at that time the tenant knew about the repairs and knew that the repairs were either negligent or not complete, and the tenant accepted the property anyway, caveat emptor applies, and the landowner / landlord / lessor is not negligent. No duty. Got it? Sit with it. Think about it. Sit with it. Think about it. Moving on. Let's look at Newton v. McGill. This one had a little more involvement in the procedure history than the Borders. Newton v. McGill, procedure history. Tenant sued landlord as the result of a slip and fall. Now, this is a man who's moved to Alaska. His wife follows him to Alaska. The wife slips and falls and breaks her ankle. So the husband and the wife, tenant, sue the landlord. Tenant sues landlord as a result of a slip and fall. The landlord / landowner / defendants move for a summary judgment. The court granted the summary judgment in favor of the landlord / landowner / defendant based upon the general landlord immunity doctrine, right? That was the same doctrine that was used in Borders. This one is 1994. Borders was 1975. So 19 years later, we're still rolling with caveat emptor. Law might be old, but it is not rescinded, right? So 1994, the defendant says, nah, you take it as you get it. Buyer beware. Yeah. Tenant plaintiff lessee, after the ruling on behalf of the landlord, filed a motion to reconsider, basically a motion for new trial. The trial court denied the motion to reconsider. The tenant plaintiff lessee appeals. What are the facts? Landowner slash landlord defendant leased home to tenant plaintiff lessee. Property had a deck partially covered. Deck had no handrails. Deck had no anti-slip materials. The tenant wife slipped and fell on the walkway due to slippery and hazardous conditions of the walkway deck. We know what the rule of law is. Rule of law is landlords have a duty, okay, to use reasonable care to discover and remedy, right, that they know of or should know of, which is present, and that's unreasonable. That's a little different. That's a little different. That expands caveat emptor a little bit, not a lot, right? It expands caveat emptor from don't even talk to me, you take it as it is. But it expands it minimally, right? Minimally. Okay. So there is a duty to do something if there's unreasonable risk, right? Why? Warranties of habitability. Why? Warranties of habitability. So is caveat emptor dead? Nope. Is caveat emptor expanded? Yep. In the instances of a warranty of habitability. The immunity of a landlord, strict caveat emptor, is no longer consistent, according to the court, because these are quotes, with the modern needs and the conditions of society. What does that mean? 1994, we were dealing with a whole bunch of slumlords. 1994, we were dealing with a whole bunch of landowners who were just completely taking major advantage of socially fragile and economically disadvantaged persons and was making them pay rents for places that were uninhabitable, right? They were just uninhabitable, right? These landlords were escaping responsibility of making sure that the conditions were not unreasonably dangerous, and they were profiting. They were profiting. And so how do we reconcile the idea of landlord tenant responsibility with the doctrine of caveat emptor? This is how we reconcile it. The landlord is going to be responsible and have a duty to maintain the physical state of the property so as to reduce unnecessary risk to the tenant. The physical state of the property, while the tenant has the duty to maintain, right? So Newton basically gave us a way to separate the responsibilities without completely obliterating caveat emptor, but definitely with deliberation, making room for the better protection of people who are renting, right? So what's the rule that we walk away with? The rule that we walk away with is landlord has a duty to the tenant to make sure that the physical state of the property is in such state that there is no unreasonable risk of harm. Now, the maintenance is going to be up to the tenant, but the actual things that need to be in place to prevent the injuries, right, the physical state, are the responsibility of the landlord. As a result of that rationale and discussion, the court reversed, let's go back, reversed the lower court's ruling on behalf of the landlord. Get it? That's landlord and tenant responsibility. Liability to the tenant, liability to the tenant's guest. If you have any questions, please let me know. This PowerPoint was posted this morning as well. As soon as this video stops converting, I will upload this video on the YouTube channel. I'll post the link along with the PowerPoint again. So this way you have the opportunity to go through the lecture with your notes, go through the lecture with your cases, go through the lecture, make sure that you're understanding the rationale, the implication, the execution, the social policy behind the doctrine. And if not, then you can make questions and let's have some conversations and let's save the world. Thank you again for the opportunity to serve. I'll see you all on Monday.